Good afternoon, everyone. My name's Anna Carpenter, and I have the immense pleasure and privilege of serving as the dean of this college. And I'm thrilled to welcome you today to the Chickasaw Nation Henry Family Lecture Series, which has been developed through a partnership of some of our university's most faithful supporters. As many of you know, this event, which was previously known as the Henry Lecture Series, was established in 2000 by members of the Henry family to inspire and educate future scholars, lawyers, and public servants. 5 members of the Henry family have graduated from the College of Law: the Honorable Lloyd H. Henry and his sons, the Honorable L. Wayne Henry and the Honorable Robert H. Henry, and the Honorable Charles T. Henry and his son, former Oklahoma Governor Brad Henry. It was Judge Robert Henry from the OU Law class of 1977 who worked closely with Dean Emeritus Andy Coates to establish this series. And over 17 lectures, the event has brought many notable speakers to the College of Law, including several sitting and retired justices from the United States Supreme Court, such as Chief John Roberts, Justice Stephen Breyer, and Justice Sandra Day O'Connor. We could not be more pleased to build upon this foundation that started by the Henry family with the support of the Chickasaw Nation, which has long been a part of OU's success. The Chickasaw Nation's impact is extensive at OU Law and beyond. I'm going to give you just a few examples. The College of Law established the Chickasaw Nation Native American Law Chair in 2013 through a gift from the tribe, allowing the university to attract and retain leading scholars in American Indian and Indigenous peoples law. Another gift from the Chickasaw Nation supported OU's creation of an endowment for the Native Nations Center for Tribal Policy and Research, which is located in the Dodge Family College of Arts and Sciences. And in 2021, the Donald E. Prey Law Library once again reimagined its space with a 1,500 square foot Chickasaw Nation active learning classroom, a dynamic learning environment that expands course instruction beyond our traditional lecture format. With all of this support, I would be remiss if I didn't recognize some distinguished individuals who we're honored to have with us today, several of whom I've already mentioned. Please hold your applause, if you would, until all of these introductions are complete. We have a few. From the Chickasaw Nation, Governor Anatubby. Joining Governor Anatubby are several key leaders from the Chickasaw Nation. If you'd stand if you're able, or raise your hand. In addition to these tribal leaders, there we go, you got it. In addition to these tribal leaders, we have several folks from the Henry family, cousins and OU Law graduates, Judge Robert Henry, and the 26th Governor of Oklahoma, Brad Henry. And although he'll be formally introduced later on, we're honored to welcome this year's lecture speaker, a foremost expert in American Indian and Indigenous peoples law, who earned his undergraduate degree from OU and is a citizen of the Chickasaw Nation, Professor Kevin Washburn. We are also grateful to have with us today United States Magistrate Judge Chris Stevens, if you'd stand or raise your hand, Chief Justice of the Oklahoma Supreme Court, Dustin Rowe, Supreme Court Justice for the Wyandot Nation, Austin Vance, former Chief Justice of the Supreme Court of the Cheyenne and Arapaho Tribes of Oklahoma, Kirk Kickingbird, former Tribal Judge for the Chickasaw Nation and Special District Judge for Carter County, Charles Tate, former Associate District Judge of Payne County, Robert Murphy Jr., and Chancellor Emeritus of the Oklahoma State Regents for Higher Education, Glenn Johnson. Now you can applaud. At OU Law, our strength is our people, our students, faculty, staff, alumni, and partners. And I've been talking about this since I got here a year and a half ago. The support and engagement of our alumni and friends and the community is what makes this College of Law so special. This event, its inception and now its expansion, is just one example of that support and that dedication in action. Today is our first Chickasaw Nation Henry Family Lecture. However, it is the 18th of these lectures if we start from the beginning. And though I didn't have the privilege of attending in prior years, I know that each speaker has brought forth a one-of-a-kind perspective that sheds light on timely issues, that allows our students and our community to see the challenges and the potential that's inherent in the practice of law. I have no doubt that today's lecture will do the same. And so it's only appropriate, as we kick off this expanded lecture series, that we do so with one of the country's foremost experts in Indian law, a field of great importance to our state and to our nation, and one of the areas of great leadership in this law school. OU has long been a leader when it comes to Indian law, and it's an area in which we continue to invest. As a state with 39 tribal nations and the second largest Native American population in the country, in Oklahoma, Indian law affects virtually all areas of legal practice, making it a vibrant and growing field. In the past decade, the U.S. Supreme Court has decided 19 cases across a wide range of subjects in Indian law. The source of much of this litigation has been a renaissance of interest of work in tribal governments over the past 50 years. For some Supreme Court justices, their entire education, their entire legal education about Native American law and tribal nations is through briefs filed in cases with the Supreme Court. Today's lecture will help us see tribes and this tribal renaissance through the lens that many Supreme Court justices use to see tribal citizens and tribal governments. And that is through active cases before the U.S. Supreme Court. Before Judge Henry introduces our speaker, I want to recognize as a group the individuals who have made today's event and future events possible. And these folks are Governor Anna Tubby, Judge Henry, Governor Henry, and Professor Kevin Washburn. We are indebted to each of you, and thank you so much for the role that you're playing in inspiring and educating our future scholars, lawyers, and public servants. And I'd like to ask you to come forward for a moment so I can offer you a small token of appreciation, and we'll take a photo. You need us to move it all? Okay.
Okay, so stay put. Look that way.
You're helping us out.
Awesome, thank you.
Thank you. Thank you so much. And you can stay. Okay, as I referenced earlier, someone who was instrumental in the inception of this lecture series and is a dedicated supporter of the College of Law is Judge Robert Henry. He's one of our most distinguished graduates. Judge Henry's legacy of leadership and service extends well beyond his contributions here. While still in law school, he was elected to the Oklahoma House of Representatives, where he served until 1986. His other accomplishments include being twice elected Attorney General of Oklahoma, spending 16 years on the 10th Circuit Court of Appeals, 2 of those as Chief Judge, and serving as Dean and Professor of Law at Oklahoma City University School of Law, and later as the 17th President of OCU. While on the bench, Judge Henry served as chair of the Judicial Conference Committee on International Judicial Relations and served on the Code of Conduct Committee, both positions appointed by then Chief Justice William Rehnquist. And this academic year, he is the inaugural jurist in residence for Rule of Law at the University of Washington School of Law. It is an honor to have you here as an OU Law alumnus and dedicated supporter and friend of our work. Please join me in welcoming Judge Henry.
I didn't know I was going to get that nice introduction from the dean, and I just feel compelled to say that when I ran for the legislature, the original election was in the summer, Governor, and I prepared to dispatch my opponents easily, but I did not, and so I was in a runoff, and so I had to make the trip to Professor Eugene Kuntz, oil and gas law professor, and I said, Professor Kuntz, do I have to drop your class, or will you waive attendance while I finish campaigning for the legislature? And he said, young man, we need you in the legislature more than I need you in oil and gas class. He said, you'll have to pass the exam on your own, but I will not take attendance. Some years ago, I ran across a medallion sculpted by the great Oklahoma Native American artist Willard Stone. Some of you know of him. He was of mixed ancestry, but his art was as Native American as you could get. He was at his best carving wood, especially walnut, which is kind of an unforgiving medium. He could also work in metal, which he rarely did, but that's the treasure I found. Willard had done a series of metal medallions of great leaders of the 5 tribes: Sequoia, Pushmataha, McIntosh, Osceola, and the one I found and had to have, Tishomingo. He was a great Chickasaw chief who led his people in war and peace and died going back and forth to the ancestral homelands to help Chickasaws make their way to Oklahoma. He fought at the Battle of Fallen Timbers with General Mad Anthony Wayne and was presented a silver peace medal. This one is not silver, by George Washington himself. This one also did not come from George Washington. In the War of 1812, he helped Andrew Jackson, that, to put it as kindly as possible, immoral, wretched ingrate, who later forced the Trail of Tears march into Indian Territory. Forgive my frankness. I was thrilled to acquire that beautiful medallion, but I knew I would have it for only a moment, for I knew where it had to go. And I found my way to Ada to present it to Governor Bill Anatubby, Tishomingo's successor, who has led the Chickasaws to heights that I doubt even Tishomingo could have seen. So, Governor, on behalf of the OU Law graduates, Judge Lloyd Henry, Judge Charles Henry, Judge Wayne Henry, Governor Brad Henry, and what's left of me, I want to thank you for this lecture and for the endowment for this university that we love. Our families have long been friends, and we've worked together in courts of law to help your great nation, a nation that refuses to be conquered by adversaries. To the Chickasaw Nation and Governor Anatubby, please. Well, the dean did her homework and took some of my things to say, but I'm glad she did, because this is a lecture series that has brought the Chief Justice of the United States, a number of distinguished speakers, including Justice O'Connor, one of perhaps my favorite jurisprud of all time. But today we are having perhaps the best speaker we've had yet. For our speaker, like Tishomingo and Governor Anatubby, is himself a proud Chickasaw. And he has an incredibly important message for Oklahoma, a state whose Choctaw name means land or home of the red man. Alan Wright's great-great-grandfather, Alan's here today, where are you, Alan, gave us that name. His message is important to America as well. The message is about the Renaissance, which means there was something before. The Renaissance means a rebirth, the Renaissance of the great Indian nations, and the return of their vibrant cultures, a culture of ethics and law, of service and altruism, to an American community that needs all of those values today. To research this introduction, I turned to a distinguished Chickasaw elder, indeed the only surviving original member of the Council of Elders, and at 90 years of age, our speaker's mother, Shirley Stark, drove herself to the lecture today. Greater love hath no mother than to drive herself to her son's law lecture. She's justly proud of her son. She says that he is a rock star and that everyone wants a piece of him. She said he's always wanted to be a lawyer since age 5. And she said that since a little boy, he seemed to think he knew everything. And she said he got that trait from her because she thought she knew everything. She enjoyed sitting on the first row of the Senate Judiciary Committee when he was confirmed to be Assistant Secretary of Indian Affairs under President Obama. And she's followed his amazing career from Ada to Yale to Washington to deanships at New Mexico and at Iowa Law, and now to the impressive Berkeley Law School, one of the great law schools in the country. She told me firmly, she said, I send protection to him every night. And I said, is that a Chickasaw thing? She said, no, that is a Christian thing. Well, Holy Writ says that the fervent prayers of a righteous man availeth much. And I would say, Kevin, that the fervent prayers of a righteous woman availeth more. Kevin's remarkable wife, Libby Rodke Washburn, is Associate CEO of the Native American Agriculture Fund, a private charitable trust that helps Native American farmers and ranchers thrive and play a vital role in stewardship and economic viability. Some of that altruism I was talking about. She revealed something to me that escaped Kevin's confirmation investigation. He has not one, but 2 motorcycles, Governor, and he joyfully uses them often, usually to take a bimble or blat to the coffee shop and read. Now, Libby is also a Chickasaw with striking blonde hair. Chickasaw statesman Charles Blackwell referred to her as Chickasaw Gold. She met Kevin at an Indian law conference, where else, and she's even succeeded in teaching him yoga, but not while he is cycling. They have 3 very interesting and accomplished children, and Governor Anatubby said he was always happy to sign their children's tribal membership, since their blood quantum with 2 Chickasaw parents did not dilute. This lecture series began many years ago to celebrate the deanship of Andy Coates and to give my family the opportunity to give back to our alma mater. The first lecture was given by a young scholar who has now gone on to be the leading constitutional law scholar in America and the dean of the prestigious University of California Law School at Berkeley. He recruited our speaker to join him on the faculty. He had this to say: "I cannot imagine anyone more qualified or better to deliver the Chickasaw Nation Henry Family Lecture than Professor Kevin Washburn. He has been a very successful dean at 2 law schools, a senior government official, and a terrific teacher and scholar. He will be president of the American Association of Law Schools in 2027. He is brilliant, wise, and a truly decent human being." So I present today Dean Kevin Washburn, a federal prosecutor, a happy motorcyclist, a law professor, a high-ranking government official, a trial attorney, general counsel, appellate attorney. Indeed, he brilliantly argued a case before me, the author or co-editor of the Bible of Indian Law, or perhaps I should say the Torah of Indian Law, Felix Cohen's Handbook of Federal Indian Law. But significantly, as Dean Chemerinsky stated, Kevin is brilliant, wise, and most important to me, decent.
I asked for that to be short. Let me, before I begin, thank some people here at the University of Oklahoma. A lot of behind-the-scenes work goes into these things. Everybody knows that. I just had to write a speech, but Associate Dean John Lee over there had to deal with logistics and politics and a lot of other icks. And I crossed paths with him nationally on a lot of things. He's a nationally known leader in legal education, so glad to have all his help. And Dean Carpenter, thank you so much for your graciousness and for having me here today. I'm so grateful for the relationship that you have developed with the Chickasaw Nation, and this law school is a wonderful relationship with the Chickasaw Nation. It's wonderful. Glad to see my former dean colleague, Kathleen Guzman, as well. We were law students together many years ago, and I won't tell you how long ago that was, but it was great to see her here as well. And I want to also thank my mom. This is probably something we all should do more of. I know I should, but she gave me the can-do spirit that kind of has propelled my career, and I'm so grateful for that. She also had a role in this renaissance that I'm talking about today with tribes. My mom was Chickasaw employee number 1 in Purcell, Oklahoma. And Purcell is a small town. It's just one of the towns within the 13 counties of the Chickasaw Nation. But she was an employee number 1 there. And I don't know how many, Governor, I don't know how many employees you've hired now since then. She found this first location for the tribe in this building, a red fabricated steel building called the Red Barn, and now there are 6 or 7 large buildings there, and a health clinic and a community center and dental and optical and all that kind of stuff. And they've done it in Tisch, Chief Justice, too. I know as well. So Governor Anatubby's been busy. But my mom was there at the beginning, and I'm so grateful for that support from her and from the Chickasaw Nation. It's a real honor to be here today. I didn't have to get a Supreme Court appointment to get here. I'm here because I'm Chickasaw, which is a wonderful thing. Also grateful to the Henry family for the support here. I will only tell one story about Robert Henry, but it will convey a little bit of the impact he has had on my life, and I just want to give you a sense of that. He's had an illustrious career, but I ran into him very early on. I came over here when I was an undergrad at the University of Oklahoma. I came over here because the Attorney General was going to be speaking. It was in the late 80s, and it was Robert Henry from Shawnee, Oklahoma. And I came over, and it was in a lower level classroom. There wasn't that many people there, maybe 20 people or 25 or 30 people. It was small, but it was kind of an open thing. And I came over, and he gave a little talk, and I decided I would ask him a question. And I was a little nervous, but I was a pretty liberal undergrad student at the time. So I raised my hand, and he called on me. And I said, I'm going to ask you a question about capital punishment. And then I posed this deep philosophical question that you might see on a T-shirt. Why do we kill people who kill people to show that killing is wrong? To his credit, he didn't take the bait. He gave me a serious answer to that question. He had clearly, he's a man, he knows the Bible, and he's thought a lot about these very, very important issues. And he treated me seriously, even though I'd asked kind of a silly question. And he just, he was just very respectful. And I left that. People always at the time asked me, why did you go to law school? And I can say, there was, a few different things, but that was one moment that I just thought, I want to be like Robert Henry someday. And Judge, I have fallen short repeatedly, but it's not been for lack of trying, I promise you. So thank you for making a difference in my life in that way and getting me on this path. And Governor, thank you for you and Kim's long leadership. I know the 8 years in the governor's mansion, but a lot of civic leadership and before and after that. We're pretty grateful for that, and really it's a joy to be associated with the Henry family in this way. And I am proud to let you all know that neither one of their names appear in the Epstein files. You'll be happy to know. Also glad to see so many great colleagues from the University of Oklahoma faculty. It's good to see you guys here. Now on to my subject, the tribal renaissance as viewed through recent Supreme Court decisions. And I'm going to try to do a lot here in a short amount of time, and I don't think I'm going to be able to do it, but we're going to do my best. 25 years ago in 2001, my friend and colleague and eventual dean of the University of Colorado Law School, David Getches, who's passed away since, he wrote an article discussing what he called the Supreme Court's subjectivism in Indian law. His argument that the court was deciding Indian law cases not on the basis of law and legal precedent, but more just on their subjective beliefs and values. And he noted that the court was rarely citing the famous trilogy from Chief Justice John Marshall any longer in its opinions. And he was looking back over the Rehnquist court, and he specifically spoke about the last 10 years when he wrote this article about 2000. So he was talking about the decade of the 1990s, basically. And he said in that article that he was really troubled by the court's decisions over that time. He wrote that tribal interests have lost in about 77% of all the Indian cases that came before the Supreme Court during that decade. And, in the Rehnquist court, 82% during that decade. So they lost 82% of the cases before the court. He said that convicted criminal felons had a better success rate than tribes before the court during that period of time. His hypothesis about subjectivism rang true to me. It also echoed the views of another great friend and mentor, Professor Philip Fricke. And about 5 years after Getches wrote that article, I was introduced to a very charming man named Antonin Scalia at an event at Harvard Law School in about 2007. And the person who introduced me said, "Justice Scalia, this is Kevin Washburn. He teaches federal Indian law." And Scalia chuckled, and he said, "Wow, you understand that stuff? We just make it up as we go along." No truer words were ever spoken. And it shows. In the Supreme Court's defense, Tribes weren't invited to Philadelphia in 1787 for the Constitutional Convention, so they didn't have a voice in this whole system, and they weren't really mentioned that much in the Constitution. And so the role of tribes in this now 250-year-old experiment that we call the United States of America is sort of unclear. One challenge for tribes is the background of the justices. Most of them are part of the coastal elite. And they don't, again, the first time they run across Indian tribes is in a Supreme Court brief or a cert petition. And and it takes a long time to learn about tribes in that way, I think. It's not a terrible way to learn history, but learning about Native American tribes from briefs and individual cases is a little like the old parable, the folk parable from India about the blind man trying to understand the elephant, by its various parts. And if you're not careful, and you don't have time to look at the whole thing, you're going to get the wrong impression about what you're looking at. And my view, my thesis is that justices, U.S. Supreme Court justices, often first encounter Indian tribes in that first case when they're on the court. That's not true for Neil Gorsuch, but it's true for many of them. And with generally only one or two cases a year, and a little bit more they learn from each piece, but it takes a long time before they see the whole elephant, and if that's the way they learn. And so that's kind of the point here today. When Justice Sandra Day O'Connor wrote a piece about tribes fairly late in her tenure on the Supreme Court, she characterized them as the third sovereign in the United States. And I think she was just passing on some civic education, which was one of her passions, and telling what she had learned in 20 years on the court, namely that there are not two, but there are three sovereign orders of government in the United States. Viewed chronologically, of course, she was wrong. Tribes are the first sovereign in the United States. They were sovereign here, before the other two existed. But the title probably reflected her own learning process. I'm sure she learned about the United States and states before she learned about tribes. So to her, they were the third sovereign, and I think that's the way it is with most justices. So let me put that all in context. I want to talk about the cases that have come before the court, but I want to talk about, there are 19 of those in the last 10 years. And first, I want to talk about the tribal renaissance and put all this, where do these cases come from? How are they reaching the court? And then I want to talk quickly through each of those cases. I can't tell you the whole story of each one, but I can give you a little bit of a sense. So let me start with the tribal renaissance. About a half century ago, in 1975, Congress passed what I'm going to call the Indian Self-Determination Act. I've shortened it a little bit. It allowed tribes to take over the programs being run by the Bureau of Indian Affairs and the Indian Health Service, and to operate those activities themselves through the tribal governments, using the money that the federal government would have used to pay the BIA or the IHS to do those programs. Those were called tribal self-determination contracts. And a lot of Native people were skeptical about whether tribes should take this on. It took time to take hold. Some were opposed because they thought it would eliminate the federal government's responsibility towards tribes. We'll start doing this work ourselves, the federal government's going to say they're not responsible anymore. When a then fairly young Chickasaw Nation governor, Bill Anatubby, a few years later, said our tribe should take over the Carl Albert Indian Hospital operated by the IHS, the Indian Health Service, in Ada, Oklahoma, I was gone by this point. I'd spent a lot of time at the Carl Albert Indian Hospital in my youth, but I was gone by then. I had gone off to law school in Washington, D.C., but I vividly recall family members, aunts, uncles, complaining about this move. Healthcare is important. We shouldn't be kicking out the federal government and try to run that ourselves. This is important. We can't do that better than the federal government. That's the kind of pointed criticism I heard of Governor Anatubby. What is he doing? But Governor Anatubby was determined. He stuck his neck out politically, and I assure you, if it hadn't gone well, he wouldn't have been reelected. It was pretty serious. But Governor Anatubby was in charge, so it didn't go wrong. It went right. And the governor won his next election, and the one after that, and the one after that, and the one after that, and I don't know how many there have been, but there he sits today, still as governor of the Chickasaw Nation. And I've always liked to say that The Chickasaw people have been very loyal to Governor Anatubby because he believed in us even when we didn't believe in ourselves. And that's really the genius of Governor Anatubby and the sheer managerial competence of getting all this stuff done. What's kind of amazing is it was overnight. And the tribe hired a lot of the same Indian Health Service people and just moved them over to the tribe. Somehow he got those very same people to do a much better job serving our people, so much that tribal members started noticing kind of right away that this is better service we're getting. And so, quite incredible. And that's part of the Chickasaw story, and I'm grateful for the governor, and I'm grateful that his wonderful son Chris is our lieutenant governor, and we've got great leadership for the Chickasaw Nation. And that's the Chickasaw story, part of the Chickasaw story. It went way on from there. And while our tribe has been very successful, maybe more successful than most, frankly, the story's been pretty similar across Indian country. Lots of tribes have succeeded because of the Indian Self-Determination Act. And many tribes have taken very similar steps, some of them following the Chickasaw Nation. There's only a few tribes, mostly treaty tribes in the Dakotas, that are still very skeptical of this idea, and they don't want any part of it. There's still a few tribes like that. But today, more than half of the annual appropriations of the BIA and the IHS are spent by tribal governments and through tribal employees doing this work. And so it's more than half of the budget. So it's the majority. And to show that this is not a partisan story, let me note that the federal official who advocated most strongly for the Indian Self-Determination Act and then signed it into law was Richard Milhouse Nixon, a Republican. So that's one of that's the sort of the start, and this started this for lots of tribes. The other real engine for this renaissance, of course, was the development of Indian gaming, which began in earnest in the 1980s, and that was also kind of controversial. When the major test of the legality of Indian gaming reached the Supreme Court in 1987 in a case called California v. Cabazon Band of Mission Indians, the United States, which is always asked or welcome to file an amicus brief, decided not to file a brief. And I once had lunch with Charlie Freed, who'd been serving as Solicitor General at the time, and I asked him, why didn't the U.S. file a brief in this case? It's one of the most important cases. Now, in hindsight, surely it's one of the most important cases that ever come before the court involving, a fight between a state and a tribe. And Solicitor Freed said that it was a complicated case. He said the DOJ, the FBI, was very opposed to gambling. They were still thinking about corruption and organized crime and money laundering and all of that kind of stuff. And they were strongly opposed. They wanted the SG to file a brief, but they wanted him to file it on behalf of California, on the opposite side of the tribes. But when Solicitor General Freed dug down into the issue, what he learned was the number one advocate within the federal government was Ronald Reagan's Secretary of the Interior, who had been pushing Indian gaming hard and encouraging tribes to start Indian gaming. And so he realized that if he pushed really hard, he was maybe going to have to go lock up the Secretary of the Interior because he was the chief conspirator in all this Indian gaming stuff. And I think he didn't want to be standing at the podium before the Supreme Court having to answer, why is one secretary encouraging something that that the other part of the government thinks is absolutely illegal? That'd be a hard question, and I wouldn't want to have to answer that myself. But that's it. The U.S. wasn't involved directly, although this Cabazon Band decision noted the federal government's great support of Indian gaming during that time. Cabazon Band won that case, and the Indian gaming revenue chart has gone up and to the right ever since. It was about $500 million a year in 1988 that gaming produced. It was a $44 billion industry in the most recent, when the numbers were counted most recently. And it won't last forever. It won't. But for now, it's still growing steadily. And the picture on the slide is the new $600 million casino opened by the Tejon tribe just in November in Bakersfield, California, which frankly is kind of the Oklahoma of California. You'd feel right at home there if you went. All those people in Grapes of Wrath, I think they all went to Bakersfield. But to put that $44 billion in revenue in context, House Appropriations Chair Tom Cole, who represents this very district and is Chickasaw, just did a miraculous thing. He got a budget, he got appropriations bills passed out of Congress. And they were very generous. The administration wanted to cut everything pretty harshly. The bills don't do that. And one of the things they do is they maintain federal funding for the BIA, the IHS, and the Bureau of Indian Education, the BIE. The current bill that Tom Cole just got passed funds them at about $13 billion a year. So $13 billion from the federal government, $44 billion from Indian gaming. That tells you Reagan was right? I mean, you give tribes the tools to do economic development, it makes a difference. And by exercising their sovereign right to engage in gaming, tribes have succeeded in ways that the federal government couldn't have done alone. And that's good for tribes, and it's probably good for our neighbors in rural Oklahoma too. What are tribes doing with the gaming revenues? They're doing a lot of things. One of them is healthcare. And one of the challenges with healthcare is we do get the money from the Indian Health Service to pay nurses and doctors' salaries and some of the supplies and that sort of thing, but it's really hard to get funding to fund new buildings and new capital expenditures, which are expensive. And so the governor built the Chickasaw Nation Medical Center, and so moved from the Carlisle Indian Hospital to the Chickasaw Nation Medical Center a few years back, and he used tribes' gaming revenues and other revenues from business, and also floated $90 million in bonds. We were trustworthy enough that we could float bonds, which is a good way to borrow. And the governor has opened a number of facilities all over the reservation and is building a new one in Newcastle now that we're all very excited about. It's going to be huge, and it's going to serve the OKC metro area and people all down I-44 all the way down to Lawton. And the tribes down there, they can utilize this service. So, and there's been great developments. So that's a big part of what the money's going. The money's going for a lot of other things too. Elder care, scholarships, buying back land, laptops for college, investing in language and cultural revitalization, you name it, social services, law enforcement. We'll talk a little bit about that. But there's a lot been going on because of the ability of tribes to start running this stuff themselves and then having this influx of investment from Indian gaming. It's really changed the lives of many Native people. And I grew up poor in Oklahoma. I would love to be, it would be different now to be Chickasaw growing up in Ada and Purcell these days, I think. And it's really exciting to see everything that's happened. Now, one thing that's happened is a lot of cases going before the U.S. Supreme Court, 19 of them. And this is a good time to look back because we're about halfway through the term that began in the first Monday of October 2025, which is called October Term 2025, OT25. No cases were granted cert this year yet, and no cases were actually granted cert last year in October Term 2024. So we had to go back to October term 2023, and only one case was decided that term. And so we're in a bit of a hiatus. So it's not a bad time to look back. There's a temporary pause. But if we go back 10 years to October term 2015, which produced some cases in 2016, we have about 19. And that's a lot for Indian law. The court was quite a bit different when those cases started coming out, when we look back 10 years ago. When that term began, Justice Kennedy and Breyer had not yet retired, and the two great opera lovers and friends, Nino Scalia and RBG, had not gone to the great opera house in the sky yet. The court had 5 Republican appointees and 4 Democrat appointees. It's changed a bit. Here's the court that we have for this term. Since 2015, those justices left the court, and we've added Justices Neil Gorsuch, Brett Kavanaugh, Amy Coney Barrett, all appointed by President Trump, and Ketanji Brown Jackson, a Biden appointee. We now have 6 Republican appointees and 3 Democrat appointees, so a little bit more lopsided politically towards Republicans. A little more gender balanced, a little more racially diverse, but more lopsided towards Republicans. Republican appointees, if you think that has anything to do with how decisions come out, that is. Note how consequential the 2016 election was. If Hillary Clinton had won that and appointed those 3 justices, it would be a vastly different court than the one we have today. Of the current court, 3 of the justices are avowed originalists: Clarence Thomas, Neil Gorsuch, and Amy Coney Barrett. Samuel Alito sometimes claims to be an originalist, but he's often willing to depart from originalism to pursue his own constitutional values in other ways. Brett Kavanaugh claims to be a constitutional pluralist. Sometimes he will look at originalism, but he'll also look at precedent, history, tradition, constitutional structure, other kinds of practical reasoning. Chief Justice John Roberts does not identify as an originalist, but he will also use originalist reasoning sometimes. He also has conservative values, but he's an institutionalist. He has a pretty pragmatic approach, and one thing I think he doesn't like is too much zigging and zagging. I think he likes to stick to precedent as much as possible. That's what an institutionalist does, is change, but cautiously change. And so that's kind of who we have on that side of the court, and I'll talk about the others later. But again, here's the cases that we have. Prior to the current hiatus, we had about 1 to 3 cases per year being decided by the court. Let me start with the most recent case from OT 2023, which arose directly from the Indian Self-Determination Act and is relevant to the tribal renaissance. And this is called Becerra v. San Carlos Apache. It's the last one there. It's a little technical, but it helps to understand the complex nature of the tribe's relationship with the federal government these days. It dealt with a subject called contract support costs, and there will be a quiz at the end. It's technical stuff, but when the tribe takes over the BIA or the IHS functions, it gets the direct payments that you would, the salaries of the doctors and the nurses and the dentists and the opticians and stuff like that. And it gets some funding for supplies, but it doesn't get funding necessarily for like HR or auditing or other things that have to be done if you have a federal contract. So Congress said we got to give tribes, in addition to the direct monies for that activity from the federal government, we also have to give them what we might in the university context called F&A or overhead. We do it with all federal research. And so tribes are entitled to that, and it's often a percentage, like 20% or 30% of the original contract amount. We're giving you this additional to cover these additional costs. Well, the Indian Self-Determination Act also tells health clinics before they spend their federal money, they have to go after third-party provider or third-party insurers and third-party payers like Medicare and Medicaid and private insurance. First, try to collect money from them, and then you can use your federal appropriations for that. Well, tribes decided we want to be, what do we do about contract support costs for that money? And IHS said, we're not going to pay you contract support costs for that money. And so tribes sued, and they won in the Ninth Circuit, and they won in the 10th Circuit, and IHS sought cert in the Supreme Court. Supreme Court ultimately said, yeah, that IHS has to pay contract support costs on those monies too, because they still require auditing, and you still have to have human resources support, and all those other things are required. And so the tribes won that, and it's a third issue like that the tribes have won this century related to contract support costs. This is not sexy, folks, but it's important for tribes. It's money, right? It's real money, and it allows tribes to do these things, and so it's important. Chief Justice Roberts wrote that decision for a 5-4 majority of the court, and it was a close one, 5-4, but it's worth several $100 million, and so that it really important for tribes. And Justice Roberts wrote the decision in part because tribes have been very clever in getting defense contractors and others that have federal contracts to come in on their side and say, yeah, you got to live up to the contract. That's what we do with government contracts. We follow them, and so that's been helpful. One of the other cases that deals directly with the Renaissance-related issues is this little bingo hall in El Paso, Texas, called the Speaking Rock Casino. Most of us know the Rio Grande is the river that separates Texas and Mexico. It turns out that the Rio Grande actually runs right straight down through the middle of New Mexico, north and south, and there's 19 pueblos located in New Mexico on or near the Rio Grande or its tributaries. There's one that, when they started drawing the lines, it was stuck below the line down in Texas near El Paso, and that's this tribe, Isleta del Sur Pueblo. And they wanted to engage in Class II Indian gaming, but they have this law called the Isleta del Sur Restoration Act that say they can't do anything that Texas law prohibits, and so Texas was trying to keep them from engaging in gaming. And they said they only want to do bingo because Texas regulates it but doesn't prohibit it. And that's pretty much what the issue was in the California v. Cabazon Band case. It was the same issue, essentially. And so the tribe took it all the way to the Supreme Court, and they prevailed in a 5-4 opinion written by Gorsuch. And it was one of Gorsuch's earlier opinions, but one of the many that he's written in Indian law. One of the funny things in Roberts dissented from this one, the Chief Justice, and he questioned whether this was really Class II bingo. Attached to his opinion, he included in the appendix a picture of what we would call a bingo slot machine, which looks like a slot machine. It looks like Class III slot machine, not a Class II bingo game. And he said that's no more bingo than the dog in the song, Bingo was his name-o. And it's kind of funny. To be fair, we sometimes call that Class 2.9 gaming because it does look a little, we're trying to, tribes are trying to kind of get the sense of the slot machine gaming in those games. But at any rate, that was the other, these are both victories and both directly related to the Renaissance. Things, gaming and Indian self-determination. But there's been a lot more, and a lot more cases, and the vast majority of them have been about criminal law. Now, I haven't lived in Oklahoma since about 1990, but I gather from the things I read in the newspapers, you've had some issues around criminal law in Oklahoma in the last few years here, and some interesting criminal law issues. So let me turn to those issues. Of the 19 cases, 7 involved criminal justice or criminal jurisdiction, and it's these 7. I think the court may be as tired of litigating these issues as some of you might be, but I've highlighted them here in green. McGirt was the middle of these. There were 3 before McGirt and 3 after McGirt, so they can kind of give you a sense of the perspective around McGirt. But it's been the single largest part of the court's docket in the last 10 years, and McGirt sits right in the middle. So I'm going to talk about each of these cases really quickly. Nebraska v. Parker was a case that holding that village of Pender, Nebraska is within the Omaha Indian Reservation in eastern Nebraska. Little town. The tribe wanted jurisdiction so that they could impose their beverage control ordinance, which meant they would license the people that are selling the liquor that was coming onto the reservation, and they could collect a 10% tribal sales tax on liquor sales. Non-members who violated were subject to up to a $10,000 fine. Not technically a criminal case, but it was an Indian country jurisdiction question, just like McGirt. And it was cited extensively in McGirt. It came out the same way as McGirt, too. It was less impactful because it was a small town in Nebraska. It wasn't Tulsa, Oklahoma. But this was a unanimous ruling in favor of the tribe written by Clarence Thomas, conservative justice, originalist. The next case was the U.S. v. Bryant. Here, Michael Bryant was being prosecuted federally because he had a lot of domestic violence convictions at the tribal level, and the tribe asked for help, basically. We need to prosecute this guy. He's a repeat offender, and tribal, limited tribal jurisdiction is not doing the job, so he was prosecuted federally. Question was whether they could use the tribal court convictions or not, because he was not represented by counsel for those convictions. The Gideon v. Wainwright principle that applies in state and federal courts does not apply directly to tribes. And so he had some of these convictions, tribal convictions, that he had no counsel for. And the court held that's okay. Those tribal court convictions are valid. It reflects a lot of trust in tribal courts because it means the tribal court is the one that's protecting the defendant's rights in those cases. Next case was Herrera v. Wyoming. This was a case by a member of the Crow Tribe of Indians. Clavin Herrera crossed over a fence line that separated the Crow Tribe, the Crow Reservation in Montana, went into the Bighorn National Forest in Wyoming by crossing that fence. And he was hunting bull elk, and it was out of season. He didn't have a Wyoming hunting permit, and it wasn't in season. And he and a couple of other tribal members were hunting, and they shot 3 bull elk, and they were charged. Herrera was charged with 2 hunting-related misdemeanors under Wyoming law. And he said, "I've got a right to hunt on former treaty lands as long as they're still unoccupied." And so, and that's what the treaty said. And there had been a case in the meantime that suggested, well, maybe the admission of Wyoming to the Union had sort of undermined the off-reservation treaty rights. And the court had actually so ruled in another case, but it hadn't been done very clearly and not clearly enough. And so that case was overruled, that old case. And the court said, forest land is not occupied land, it's still unoccupied, and this off-reservation treaty right still applies. And so they overturned the convictions at the state level, so the tribe prevailed, and this was a 5-4 decision. And then we get to McGirt, and I don't think I probably need to tell you all too much about McGirt. When this decision came down, I was sitting in my basement trying to figure out how Zoom works. Remember that? Remember that awful period of time in our lives? And this was just some of the sort of the chaos from that time. But as you all probably know, the language in the treaties for the Muskogee Creek Nation is very similar to the language for many other tribes in their treaties. And so it ended up having much broader application than just to Muskogee Creek. This case was one in which it was 5-4 decision, and Roberts and Clarence Thomas both wrote dissents, and it was disruptive. It's hard to start following the law when you haven't followed it for more than a century. It's a complicated thing. My cousin was the Chief Justice of the Chickasaw Nation during the time they were trying to implement McGirt, and they went from hearing 75 cases a year to 50 cases a week. Mistakes will be made, right? You do volume like that. Governor Anatubby was very supportive of hiring court personnel and judges and prosecutors and defense attorneys and everything they needed to do this right. But it's hard, right? I mean, we will see mistakes. And more light horse police officers too. So there's been a lot more activity. Things have changed quite a bit, but so far so good. The next case that came down, by the way, after McGirt, the state of Oklahoma filed numerous cert petitions trying to get McGirt reconsidered. Instead, they took cert in this case, Cooley. The court rejected all the McGirt cert petitions from Oklahoma, but it did take cert in this case out of the Ninth Circuit. In this case, a Crow tribal police officer rolled up on a pickup truck that was sitting on the side of the road and went to check it out, and he saw someone that had bloodshot eyes and appeared to be non-native, but he had 2 semi-automatic weapons on the front seat of the pickup truck, and he thought he probably ought to do something about that. So he called in backup, and he got the guy out of the truck and patted him down and searched him and all that. And he then called for assistance, and the case went up. The feds decided to prosecute him on narcotics and drug charges. And the district court in the Ninth Circuit said that evidence has to be suppressed because the tribe didn't have jurisdiction to prosecute those offenses, so their search was invalid. Supreme Court unanimously overruled that and said no, the tribe had every right to stop somebody or detain somebody in those circumstances and do a search because lives were in danger. And the Supreme Court made clear that there could have been all kinds of danger, running contraband, drunk driving, any other kind of crime that might harm reservation folks. And so there was jurisdiction. So the court was very supportive. Reversed the Ninth Circuit unanimously. The next case was Dinespe versus United States. This case, the gist of this case, is that the Supreme Court continues to recognize the doctrine of dual sovereignty, which means that both the tribe and the feds can prosecute the same person for the same offense. A little more complicated than that in this case, but it was a 6-3 opinion. Actually, the interesting thing was Gorsuch dissented because he doesn't think anybody should be prosecuted twice by any of the American family of governments, is the way I think he put it, which kind of makes sense. People shouldn't be prosecuted more than once for the same crime. But he's highly, he doesn't like the exception to the double jeopardy clause in that way. Castro Huerta, in the aftermath of McGirt, this is the case that the Supreme Court took cert in. This is somewhat related to McGirt. Castro Huerta was a non-Indian who'd been prosecuted by the state for serious child neglect, but his victim was a Native American. Before this case came down, we would have said that's exclusive federal jurisdiction. State has no jurisdiction there because there's a federal interest, and that federal interest preempts any state jurisdiction. The court, in this case, made new law, and said no, there is state jurisdiction here. And it's been really a controversial case with Indian law scholars, and it certainly, a lot of us don't like the way it was written because it was not respectful to some of our most important precedent. But the outcome is not particularly anti-tribal. We've been complaining for years that with the MMIW, the Missing and Murdered Indigenous Women, and MMIP, Missing and Murdered Indigenous Peoples problem, that the problem is largely non-Indians who come on the reservations and behave with impunity. If that's the argument, then adding another group of people that can put boots on the ground to help solve that problem is not necessarily a bad thing. So it could create confusion where, the jury's still out, I guess I would say, about whether Castro Huerta is a good thing or a bad thing. But it didn't undermine the basic idea that states don't have any jurisdiction over Indians on Indian reservations. And this one is written by Kavanaugh. And again, I would have written it differently, but I'm not sure it's bad for tribes. So for those who've not been paying attention, we have 7 majority opinions written by 7 different judges from across the ideological spectrum, and tribes or their interests clearly prevailed in 6 of them. So it's there, and McGirt, again, we could argue about. But that's kind of what's going on. I'm going to skip ahead a little bit here, although let me just note that the same thing's been going on in Congress. The Supreme Court's been very respectful of tribal criminal justice authority. So has Congress. Congress has been restoring and expanding and recognizing tribal criminal jurisdiction consistently. And you can see, and this is nonpartisan too. This is Obama signing the Tribal Law and Order Act in 2010, but you can see John Barrasso, the current senior Senator Majority Whip, senior leadership of the Republican side, standing right next to him, and there's Tom Cole over there on your right as well at the table. And John Thune was there too. He was sitting right next to me. And he's now the Majority Leader of the Senate. So this is pretty bipartisan. Trump's been doing similar things too. Trump actually took away state jurisdiction for the Meskwaki Reservation and did a retrocession that had to go through Congress. So now the feds and the tribes have exclusive jurisdiction on the Meskwaki Reservation without state jurisdiction. So even Trump has been doing this stuff. It's been happening a lot. I'm going to skip that because I got to keep moving. So the other good news for tribes is they had 2 cases that were affirmed by an equally divided court. That means there was a 4-4 tie, and the court couldn't come up with an opinion, so it had to just affirm the lower court, in which case both of them were wins by the tribe in the lower court. One of them was this Washington versus United States. This was about a fishing rights. State of Washington was required to change the culverts underneath roads that for fish passage. And they said that's going to cost us $2 billion to do all this, to make sure that the tribe's fishing treaty rights are protected. It's just too much. And the district court and the Ninth Circuit disagreed, and it got up to the Supreme Court, and it was affirmed by an equally divided court. Because Justice Kennedy had to recuse. The other one is this Dollar General Corporation case. And this one, in this case, Dollar General had a store on the Mississippi Choctaw Reservation and in Mississippi. And they had an internship program, and they had a 13-year-old tribal member, young man, John Doe, who was working in the internship program, and the store manager allegedly sexually molested him. So they brought suit, and they brought suit in the tribal court. Interestingly, curiously perhaps, the district court in the Fifth Circuit said, we don't have jurisdiction over the manager who did the molesting, but we do have jurisdiction over Dollar General because they signed a contract with the tribe. So they've got a consensual relationship with the tribe. They knew the tribe was a government, and they knew tribe had courts, and they signed that contract. So the Fifth Circuit said there is jurisdiction here. The case was argued in December 2015, but Justice Scalia passed away in February before a decision came out. I don't know how he would have voted, but it came out 4-4. We've been waiting for that case to go up again. These three cases can be grouped together, sovereign immunity cases. People in the United States do not like sovereign immunity, and I don't blame them. It's a controversial feature of American law. The idea of sovereign immunity is the king can do no wrong. It's one of the reasons that the colonists sent the Declaration of Independence over to the king. We don't like this. You're unaccountable. What government should not be unaccountable to the people? Well, it's not in the Constitution, and Congress didn't enact it, but the courts decided, well, it's kind of an inherent part of sovereignty, so it exists. And people have been kind of mad about that ever since. And these cases all arise out of that basic principle. The Supreme Court's been very even-handed about sovereign immunity. If it comes from sovereignty, tribes have it too. And so in this first case, Lewis v. Clark, a limousine driver for a casino, was sued for a routine auto accident case on a public highway in Connecticut. He rear-ended somebody, and they sued him. And it happens every day in state courts, right? This is just an auto accident case. The wrinkle is that he was working for the tribe when it happened, and he was not acting in his official capacity. That would have put this into a different category. He was sued in his personal capacity, but he said, but I have an indemnification agreement in my contract with the tribe, and so I should be allowed to use their sovereign immunity. And the court said, no, you can't do that. That was an 8-0 decision. Patchak v. Zinke was a case that arose when the Secretary of the Interior took land into trust for the Machibenishiwish tribe of Michigan. They call it the Gun Lake tribe for a reason. It's hard to say that word. Machibenishiwish, that's it. And a nearby landowner sued the Secretary of the Interior for taking this land into trust for the tribe, and said he didn't do it was not proper to take that land into trust, and prevailed actually in the U.S. Supreme Court on that argument. However, Congress acted pretty quickly and said, we ratify that taking into trust, and we support what the Secretary did, so we are stripping the court of jurisdiction over this case, the courts any further of this case. And that brought another case that reached the Supreme Court, and it was a 6-3 decision, with the dissent being outraged that Congress could strip jurisdiction from somebody after they had won their case, in essence. But the majority, 6 justices, held it's a waiver. I mean, tribes, the U.S. had to waive its sovereign immunity for this case to be brought, and they can undo that waiver any time, and they did so here. So the tribe ended up winning that in kind of an unusual way. And then the last one is this Upper Skagit tribe versus Lundgren. And this decision is not a model of clarity, but here the Lundgrens had sued for adverse possession of land that they said they owned, that the tribe currently had title to. They brought an in rem action against the land rather than against the tribe, trying to get around sovereign immunity. And the court said, no, in rem actions are not, it's not an end around on sovereign immunity. Good try, basically, but we're not going to allow it. And so that's how that case ended. All right. So I'm going to skip a couple of these cases. But there's been let me talk about the 2 losses for tribes, the clear losses that are on here. And those are Arizona v. Navajo Nation and Lac du Flambeau Band of Chippewa versus Coughlin. And I've got them in red at the bottom of the slides because I think they are clear losses for the tribes. I wanted to point them out. The Navajo Nation has water rights in the Colorado River. And the Colorado River its flow is diminishing. Lake Powell is starting to dry up, and all along the river things are drying up. And but it serves water to 7 states and numerous Indian reservations, and that river is under real stress. The Navajo's water rights are held in trust by the federal government. The problem is that the federal government has never made any effort to quantify how much those water rights, what is their right, how much is their right, how much water is the Navajo Nation entitled to receive, how much water is the U.S. holding in trust, or it's made no effort to get the Navajo what we call wet water. They've got maybe paper water rights, but they don't have wet water. And so there's no question that the U.S. is the trustee for these assets. There's no question that the U.S. is not doing the job that a trustee should be doing. The tribe sued, and the court ruled in a 5-4 decision by Kavanaugh that ordinary trust rules just don't apply here. And the United States may be the trustee, but unless there's a statute that says the tribe can sue for this type of breach, there can be no suit. And so that was a devastating decision. It makes crystal clear that the so-called federal trust responsibility is really just a moral responsibility, not very rarely a legally enforceable duty. Alex Pearl litigated this for many, many years and kind of found the same thing. He kept winning, sort of, but never couldn't get complete victory because it's easy to prove government misfeasance and malfeasance. It's hard to get them accountable for that, and that's what this case showed. Lac du Flambeau Band of Chippewa versus Coughlin was a loss for the tribe. It said tribes are subject to the automatic stay in bankruptcy law. Whenever someone files bankruptcy, everybody has to stop collection efforts. It says governments have to respond to that too. It says all governments, foreign and domestic. It didn't say tribes, so tribes said it doesn't apply to us. And says the Supreme Court said it says all governments, foreign, domestic. You're in that batch, even though we didn't mention tribes. And it's and they wrote a very respectful decision about how important tribes were as governments in the United States. So that was a loss, but it was not a negative case particularly. The biggest victory was Brackeen versus Holland in 2023. This case threatened to take down the Indian Child Welfare Act, and it was a big tribal victory because people were pretty worried about it. But it ended up being a big win, written by Amy Coney Barrett, who has written 2 decisions in her short time on the U.S. Supreme Court, and they have both been favorable to tribes. And she took the position, the spot held by RBG, who was not terribly favorable to tribes, certainly early in her career, and a little bit better later in her career. But Amy Coney Barrett actually may be a reason for hope for tribes on the Supreme Court. I'm going to kind of skip ahead. One of the things to look at here is who wrote the opinions? As politics, just as we saw that Nixon and Reagan were key to the tribal renaissance, what does politics say about these decisions? Gorsuch on the right is the most reliable vote for tribes, and he, of course, came to the court from Judge Henry's court. So he knew about tribes before he arrived at the Supreme Court. Of these 19 cases, with only 2 cases in which tribes really lost, about half the opinions were written by Republican appointees and about half by Democrat appointees. And I mean all the majority opinions. Sotomayor is the most reliable vote from the left, but tribes can count on her for the most part. But again, Amy Coney Barrett is looking pretty good so far. And we saw that Chief Justice Roberts sometimes rules for tribes too. So tribes have a fair forum when they go to the Supreme Court. Justice Samuel Alito is the most reliable anti-tribal vote. And I think that he's probably not going to change, no matter how many times he goes around the elephant and sees more cases. That said, he's the 3rd most senior justice, and rumors again this week emerged that he's probably going to retire soon, and so that Trump can fill his seat. So, and you just don't know. Trump appointed Gorsuch and Amy Coney Barrett, so we just never know what we're going to get because this stuff does not break along partisan lines. That is. All right. So what I think I've shown you is the work of government can be kind of tedious. None of these cases fully showcase the vibrancy of tribes and what's going on and their cultural value and all of that. Think what we've seen is they're winning. They're winning in the Supreme Court. They're winning in Congress too, but they're winning in the Supreme Court. So if we circle back to that initial question that David Getches took up, he said, you will recall, that tribes had lost 82% of the cases they brought before the court in the 1990s, in that decade. That figure has just about reversed in recent years. I put the ones where tribes did prevail in green, where they did not in red, and the ones that are kind of wobblers that you can't quite, it's not quite clear in yellow. But tribes or tribal interests unquestionably prevailed in 14 of the 19 cases before the Supreme Court in the last 10 years. They clearly lost 2. And then again, there's like Castro Huerta. What do we know about, where are we going to put that one? I'm not sure. It may end up in the loser in the category, but we're just not sure. So from an 80% loss rate in the 1990s, tribes would seem to have at least a 74% clear win rate in the last 10 years. And only an 11% clear loss rate. 2 of the clear losses were down there at the bottom, so those are more recent. But Arizona v. Navajo Nation, which is written by Kavanaugh, and he hasn't heard very many cases yet. He's still fairly new to the court. And Lac du Flambeau is written by Ketanji Brown Jackson. Both of these are people who fit that mold. They're members of the coastal elite. They probably didn't know much about Indian law until they got to the U.S. Supreme Court, and this is how they're learning it. And it might take them a while, but they may follow the path of RBG and Sandra Day O'Connor and become more favorable towards tribes over time. So, 19 cases. For those of you who are still here and awake, that was hard-earned CLE credit. I congratulate you on doing the hard work. And so I'm going to wrap up there. I got my point across. I'll stop. Thank you for listening. Thank you.
Thank you so much, Professor Washburn, for your insights today. We appreciate it so much. And thank you to all of you for joining us. I hope you will leave here educated, motivated, inspired, maybe to learn more. And we will, for those of you who want to stick around, there's a light lunch in the foyer that you can exit to. And I wish you all a wonderful day. Thank you.